Okay.
Good evening. My name's Pat Mellen. I'm an attorney. Mellen, M-E-L-L-E-N.
I'm sorry.
Really bad handwriting. I'm understanding.
My apologies.
That's okay. In an effort to focus on suggestions, recommendations, I think there is a over-reliance that I've seen in this particular municipality on the concept of use by right. That either the population doesn't understand or doesn't agree with. Because a use by right doesn't feel like a use by right when there are easements that are being vacated and lot lines that are being changed and fee in lieu decisions that are being made that abandon land dedications, and exceptions are being allowed to open space within a zoning designation. Those don't feel like use by right. Those feel like a lot of discretion being executed by the city staff. So I think if there were parameters that were given or voted on, I don't know, but agreed to by the community of if these things are going to be changed, it's no longer appropriate for it to be only through a staff process. Second, I'm here to tell you that, and all I do is residential land use and residential land litigation. The use of a piece of property by an owner is a very protected right in the state of Colorado. But that right ends when what your use is going to be affects your neighbors. It's called a nuisance or trespassing. So even though it feels like a use by right, if that use affects the neighbors, then they have a say. And the issue in this particular, in some of the parkland question, is the fact that the parks are owned by the city. They are not owned by the citizens. And they are not owned in trust for the citizens. They're owned by the city. And so the options that the citizens have to say, I have an interest in that parkland, are very slim. And the Lakewood ordinances could use a park overlay concept that includes the ability for the people who use and can demonstrate use of that parkland to have a voice in things that will affect the parkland. I also would recommend that you guys put a waiver in your applications that developers understand that they are proceeding at their own risk. And so to hear a mayor or anyone else in any position of power in a municipality make decisions or avoid making decisions for fear of being sued makes me sad for my profession. We shouldn't be putting you in that position.
Questions? Commissioner Furman.
So you described the use by right being not enforced when their property being developed is going to have a development that is a nuisance. Do you, I guess, without talking about particular projects, do you have, in your professional opinion, what is defining that thing as a nuisance such that it could be put into a code? I mean, I guess my question is there a way for it to be more than an opinion, a way that it can be codified? Sure. Such that
nuisance has a definition. So it's something that interferes with my ability to use the quiet enjoyment of my property. So it's things like smells, dog waste that ends up on my property. It's light infringement. I mean, nuisance has a legal definition. And so to the degree that any project could be anticipated to have that kind of impact on a neighboring property, it could be included as a criteria. The issue becomes the citizens of Lakewood don't own, and I don't want to get into a particular project, but where the city owns the neighboring land, the city can in fact waive all that and say, I'm not going to care about that. but the people who actually use the property do care. So the city has a bit of a conflict of interest in those nuisance definitions because they're approving things that allow for nuisances because they can.
You are an attorney, right?
Yes, I am.
Great, then you're the right person.
I can't give you legal advice.
I understand, but you're the right.
City attorneys will have my head.
You're the right person for this question, though. In your view, when is the appropriate time in a development process for there to be vested rights? Because you're suggesting that a developer who applies could be required to sign a waiver saying, I'm proceeding at my own risk. Is there any point in the development process when there is a vested right?
You know, I haven't researched that. That's a good question. Okay. I don't do development work.
Right.
But there is a continuum,
right?
And I feel like your elected leaders aren't comfortable, or there are projects where there's particular timelines that have happened and investments that have happened that have gotten you guys to some very weird places. So maybe one of the things you need to do is add a time limit that if a certain project hasn't been approved by a certain time period, that other things happen. Because the longer you get into a project and the more expectations that are out there and the more money that is spent, obviously there's a bigger investment and a bigger feeling of risk.
Right. But at some point, a property owner gets vested rights. That's a pretty well-established notion, right?
Yeah, but I'm not sure that a developer asking for things that are outside, and again, this is not my, development is not my area of law, but logically, throwing a bunch of money at something to try and get a municipality to agree to concessions, you shouldn't be able to buy vested rights just by the amount of money you throw at it.
The park overlay idea, I'm really intrigued by this. So the thought would be, because I think I heard you say that you could have an overlay. So the first question would be, how far from it, the park, would that apply? And then secondly, that if in that overlay area, there would be some recognized community engagement, participation. So if you could elaborate on both of those, how far away do you think that's appropriate, and what would be that guaranteed participation?
Well, so Jefferson County, unincorporated Jefferson County has a similar concept where if you're going to do a subdivision of a particular land, I worked with a gentleman who was trying to subdivide some land in unincorporated Jefferson County. Notices went out to everyone within, I want to say it was half a mile radius from the center of his property. And the difficulty in Lakewood is that your ordinances in the planning subsection 2 is that you have to have an adjoining property, right? It's not within a particular radius. It has to be adjoining. And so that's in some very specific carve out properties, that's a real problem. So I could see a half a mile, I could see a quarter mile from the center of, center of balance, or what do you want to call it, from the center of a property. Half a mile in a circle will get you a certain number of people who have a right to have notice of a particular development that's at the application point. So my understanding, and most municipalities do this, there's a pre-application screening of, here's where you're probably going to have problems, here's what you need to look at drainage, or you need to look at access, or you need to look at any kind of grading that needs to be done, right? So that pre-application process feels like a good time to talk about what the radius should be.
So that might change project to project, you're saying?
Might change project to project. That's an option.
Okay.
Or you could have a fixed one. A pre-application screening process, it feels a bit early because you're not committed to that design yet. It's really just, my understanding from my experience is it's much more sort of blue sky.
Right.
We're thinking about doing this. Now, when you've got an application that is being sent out, referred out to staff for opinions and analysis and applications, that is absolutely the right time and not later.
Okay. Great. Commissioner Kentner.
I hate to leave Miss Mellen standing here for too long, but I would like to opine
don't
just
get me yelled.
briefly. It was something that I did study up a little bit on in preparation for this meeting, and would like to recommend if all my fellow planning commissioners do not yet have a copy of the most recent Colorado Land Planning and Development Law Book. It might be a useful document. And as far as the vesting and when things vest, neither the Colorado Supreme Court nor the Colorado Court of Appeals has addressed whether common law development rights will vest for a site plan, even if they were to decide that vested rights
Commissioner,
arise.
out of respect to the people who have come here to talk to us, we're going to have a chance to discuss if there's something you want us. But do you have a question for?
I don't think I do in this, other than would you agree with this, that, site plan does not necessarily give a vested right. It would seem that
I'm willing to agree with that book. I haven't
Okay.
studied it myself. How's
Thank
that?
you. Thank you for your time tonight.
All right. Thank you so much.
All right, thank you.
Carol McCoy.